Welcome back to Settlement Nation podcast and our Confessions of a Defense Attorney Part 4. You asked and we delivered on our most popular and downloaded episode and series, which is now back for the long-awaited Part 4. Here with me today is Jason Neville from the Spence law firm and Jakob Norman from Trial Lawyers for Justice, both respected and seasoned plaintiff trial lawyers who started their careers working for the defense. We have had so many comments, questions, and feedback about the Confession series. We thought it was only right to bring these Wyoming boys back into the studio so they can share more of their 18 plus years of wisdom, advice, and tips for all of our plaintiff attorney friends out there. So welcome, Jakob and Jason.
Hi, guys.
Hey, Courtney.
Well, how is it to be back for Part 4, guys? I know that it's been a while since we did the last one in 2020, but I do have to say it is our most popular episode and series ever. So I'm really excited that you're back today sharing more of your great expertise with all of our listeners.
Well, yeah, it's good to be back. And, you know, it's funny as these episodes have come out and people have listened to them, you know, hearing feedback from plaintiffs lawyers and even defense lawyers about how much is sort of unknown about what goes on behind the curtain. It just sort of brings back why this is so important. And there are things that I think are, you know, just obvious and known, and I'm sure Jakob as well, but they're not known. And these things, if we make them known, I think only is going to enhance our ability as a whole to represent our clients and maximize those results.
Yeah, and who knew that a couple guys that went to elementary school together in Wyoming would have more downloads than some of these other great attorneys. But it turns out that, you know, I take working in the defense in the beginning as pride. I was when I got hired, I was surprised anyone would pay me to work. But I think there's a lot of people who say, oh, well, I've never done it. And Jason, of course, did it for 19 years before he switched over. But there's a way that you're able to communicate a case. There's a way that you're able to understand the workup of a case. And I think there's a lot of lessons learned. And I'm proud to have started there. It taught me a whole lot of why I'm doing what I'm doing now. And I think it makes you better. So again, on one hand, there's folks that are happy to say they've never done it, but I think those of us that have done it should be you know, kind of happy that's where we're started and take the lessons learned and do better for our clients. So it's great to be back with you again. And I think, Jason, when folks either talk to me about this episode or talk to Courtney about this episode, there's still this kind of unknown of what the defense is doing and why, and reserve seems to be that kind of touch point. How are plaintiffs' attorneys getting reserves to be changed? Are they failing at getting reserves to be changed? You know, there's this often thing, well, let me talk to your supervisor, and that's not really the way it works. So maybe it'd be helpful to go back to approach reserves from the defense perspective again, and if you could just give people a little bit of insight on that process and when is the best time to really get this process going and what's different about giving a lot of information in the beginning compared to later. Do you mind like kind of going back over reserves?
No, not at all, because it really is such an important part for us to move the cases forward. And move them forward as quickly as we can. It's this sort of unknown foundation that we start building from the very beginning that we have some control over, of course, with the information we provide, but we don't have the ultimate control over it. So the reserves are set by the insurance company to sort of set aside money that they think is going to be ultimately paid out both for the defense of the case, you know, for their attorneys and expert witnesses, as well as for the indemnity, which is the ultimate payout, either in settlement or a verdict. And so it's important for them to keep their books appropriate, what have you, to set these out and to set them accurately. The problem is the people that are setting them are the individual adjusters. And it's not a committee that sets them, initially, it's the adjuster. And so if you think about having an ordinary car accident case, you have a pre-litigation adjuster that's on it, and they're usually the low-level adjusters, and they don't have much of any authority to really settle cases unless they can get them done for super cheap. And then in those people, they're tasked with setting a reserve, and it's a box that they have to check with whatever procedures they have in their company and on their software. And so they set the reserve. And some of these companies, if a reserve is not set, say within 30 days or some sort of time frame from when the claim comes in, it's set as $25,000. Or maybe it's $15,000. A reserve always has to be set for the books, right? And then when you move up, when you file suit, then you get to a litigation adjuster, and they then will look at the reserve and take the information from the complaint and anything that they've gotten from the investigation that the underlying insurance adjuster did, and they'll redo the reserve. And then if it moves up from there, they look at it and they say, oh gosh, this is catastrophic. This is beyond my pay grade. It'll go up from there. But the importance is these people are setting the reserve based upon the information that they have. It's all that they can do. And so if we pre-litigation are giving them all of the medical records, right? Or we're giving them, if we have had it worked up with respect to damage experts, they then can take that information and put it in to set the reserve. And that reserve, once it's set, and I know we've talked about this at length in prior episodes, once it's set, it is a big cruise ship that takes, or big barge, big oil ship, right? That takes a long time to change course. And once it's set, it's not just something that automatically that adjuster can just redo sort of willy-nilly, because they have to explain their actions to their supervisors. And so it's very important to get all of that necessary information out there as quickly as you can to get that reserve set adequately.
Well, Jason, before we go too far in turning the ship around, which understand that's a monumental task, there's certain jurisdictions. Wyoming's one of them. We have a 4-year statute of limitations. Some are 3, some are 2, and some are even longer. And there's this idea, well, let me as the plaintiff's attorney work the case up, see how treatment goes. And I'm not going to communicate anything with the insurance company because I don't have to. I have a long time before I have to file suit. Let's see how this goes. Then I'll get them, more information later. It sounds like you're saying that could have a major negative impact on the setting of the reserves.
Yeah, I think so. Because they'll set it, based upon the information that they have. And so if you're out there and, it's a significant case, for example, and what they have is insignificant, there's always that question. I know we've talked about it, of what changed. And that's a question that as a defense lawyer, I would always get when all of a sudden my evaluation changed on the value of a case. And it's something that these adjusters always are going to get from their supervisors, and they have to justify all of these changes. And so when you have a larger reserve with more information, set in the beginning, it makes all of those processes easier.
Well, okay, so let's, and do you have I guess a little bit of inside information on how you have to then become an advocate for the value of the case when they've been set wrong? How does that interaction work between, you and the insurance companies? And I'm really specifically talking about when it's lower, obviously. I think the listeners of this are probably dealing with it being set on the lower side, not the higher side.
Yeah. So are you asking that from what the defense lawyer does or what we should do?
No, when you were a defense lawyer, and then I want to get to us, like, how did you, it seems from time to time, and I know when I did it, you would have to be convincing the insurance company they're wrong on the valuation. How's that kind of back and forth like as you're you start to become an advocate for a higher value, which might make you as a defense attorney seem like you're on the wrong side, but it's still right for the case. Could you explain a little bit of that?
Yeah, for sure. So, one thing is that it should, and this is the way that it should be. It isn't always this way, but the setting of the reserves, the defense lawyer doesn't have any direct input on that. Like they don't come in and say, hey, your reserve should be X, Y, Z. You don't get a direct question from the adjuster. Hey, what do you think our reserve should be? That happened sometimes, but every time that happened with me, it was, hey, I shouldn't be asking you this, but what do you think? Right? What they do is they take that setting of the reserve when it's sometimes if it's pre-litigation, if they have a defense attorney involved, or post-litigation once it begins with the initial report. And these initial reports, the defense lawyer is setting out, this is what the expected median settlement of this case is. This is what the expected median verdict of this case is. This is what a runaway jury might do, or a nuclear verdict might look like. And so the adjuster is then taking all of that information and then setting that reserve. And so so the defense lawyer doesn't have this direct input, even though it kind of is, right? Changing that is having to always point out, this is something that is new. This is something, we didn't know that they weren't able to work, or we didn't know that, their job was $100,000 a year job, and now they can't work. And so it's always answering that question, what changed, right? And we didn't know this ahead of time, meaning my first litigation report was correct to you. But now that we know X, Y, Z, this is my new report and new valuation. And that's what's changed. And that's why, from the defense lawyer standpoint, adjuster, you should be thinking of this differently. What they then do with that from the defense lawyer side is unknown, whether they change that reserve, because they might just put that in a report and never get to changing the reserve.
Yeah. And Jason, I think that's important, because I used to write some of the same letters you had to write, obviously not for as long, just even summarizing perceptions of the plaintiff after deposition, stuff like that. But could you maybe talk a little bit about, are you given an analysis, were you given an analysis to these insurance companies about the skill of the attorney? In other words, if they're a mill and never go to trial, is that a factor you're considering when telling them the values? Or if it's known trial lawyer that is really going to go to court, they're going to stick to it when they say they're going to court, and they're known to be good in trial, is that part of your evaluation when coming up with the value of the case at the time that you were doing this?
Oh yeah, for sure. For sure it is. I mean, because if you have somebody, and I'll stick with medical negligence just because that's sort of a clear line that in my view is sort of different, and you could put in products liability or some other sort of more specialty type of case. But let's say that that you've got somebody that has never done a medical negligence case before. And I know this, right? Because I know them, and I know that they do a lot of car accidents, and they're great at car accidents, but they've never done a med mal case. Well, that tells me they don't know where to get all the experts. And if I know what kind of sort of firm they're coming from, maybe it's a small firm, they're not going to be able to fund $200,000 and keep that on their books, for a couple of years to go take this case on. And then on top of that, do they have the skill set at trial to, defeat what, at least in Wyoming and in many places across the United States, is this sort of bent towards hospitals, a defense bent towards hospitals and doctors. And so that is something, and there's a separate section in every report that I've ever done from the insurance company. And you're evaluating the judge, you're evaluating the jurisdiction, and you're evaluating the other attorney. And we've talked about this. The only power that we have on this side is a jury, and that threat and the risk of going to trial. And if that threat is taken off from the beginning, well, they can just bleed the plaintiff dry and let them hang out there and go through it. And they know, well, they're going to try to settle it at the end. And they don't have the wherewithal, the finances, or the skill set to go to trial. And so it's a huge part of it.
Yeah, and I really appreciate you talking about that. We talk about it a lot in training. You can write all the settlement opportunity letters you want. You can do everything. But if you're not going to trial, they know that. They talk about it, and that's a consideration. So we really need to be taking the trials that should go to trial, and of course settling the ones that should be settled. But it seems like usually that's inverse. We're oftentimes seeing people take to trial the ones that should have been settled and settling the ones that should have been taken to trial. So it's a learning situation for us all the time, but I think everybody needs to know what's happening behind the scenes in that regard.
Yeah, no, absolutely. And that's the thing. They have all the money, and, they essentially have all the time. And, we know this because you're working with people whose lives have been changed. And it doesn't matter if it's from a quote unquote minor injury, or if it's catastrophic. Their lives have been changed, and most people want the case done from the plaintiff side, these plaintiffs, and the prospect of going to trial is scary. I mean, it's just scary. It's risky, of course, but reliving everything and then having to go through that and sit there for days or many weeks or months, it's very daunting. And, these insurance companies, from a business perspective, they exploit that. They exploit that for sure. And when we have plaintiffs, clients who have the strength to go to trial, and it's right, and it's right for them, we have to do that because that's the only power we have.
And Jason, I'm going to go off topic slightly, but it's November right now. We're talking about reserves. A lot of plaintiffs' law firms will send out kind of end of the year settlement opportunity letters, or really try and resolve cases with this belief that that's something the insurance company wants to do as well. Can you talk a little bit about end of the year issues? Is that a myth? Is it a fact? Is it a little bit of both?
Yeah, it's I don't think it's a myth. I think it's very real, but it depends upon the insurance company, and it depends upon the year that they're having. I would get sometimes at about this time of year, start to get calls from certain insurance carriers, and they would say, "Hey, we got to get these cases settled." And I had some of them at times tell me, "Hey, I'm not supposed to tell you this, but we need to get this off our books this year. So let's go get it done. And even if you have to pay more to get it done, get it done." And so it's not a myth. It's not going to happen in with respect to every case or every carrier, but it's for sure out there. And it's a smart thing to do to give them an opportunity to get it off their books.
Great. And on that same note, so again, with reserves, thinking about potentially resolving stuff within the year, there's often talk on the plaintiff side about, defense gets paid hourly. They don't really care. They don't care if they have to appeal. They'll write it out for however long, but there's a minimum amount of workup that has to be done. I think people on our side, the plaintiff side, still kind of complain about it, but can you talk about just the general workup, the defense workup that's necessary to even make good choices in determining whether a case should be settled or go to trial?
Yeah. So, I think for the moral and ethical defense lawyer, they need to have enough information so that they can give an analysis that's proper, so that, you can feel confident that, hey, this is the proper analysis based upon all the information that I know right now. And I think we kind of know all the right information, and we can, pretty much surmise or guess what some of the unknowns or how that's going to shake out. So this is what we have, and this is why, I'm saying X, Y, Z. That might be in many cases deposing the plaintiff. Just because so much, not so much, but a lot of evaluation is, what is this plaintiff like? Are they, the star perfect plaintiff that is going to walk into a jury and everyone is going to love? Or is it someone that's horribly hurt, that is, they're hurt not because of their fault, but there's just something about them. Maybe it's a history of drug use. Maybe it's some sort of criminal record that the jury's going to hate them, right? And so getting your eyes on that plaintiff and trying to see how is that going to play out really can affect the value that you put on a case. And so for anything but small cases, I think you're most likely going to have to go through and have your client deposed.
Well, let's talk about then when it goes all the way wrong on the other side, and this is bad faith. Again, it's this idea that we're setting the defense up for bad faith, I think, is probably the wrong vernacular to use. I don't think we should use the word setup. I think there's certain things we should do, and if the defense, by choice or error, whatever it is, commits bad faith, that's kind of a potential where this can end up. But maybe you could talk to us a little bit about, and I know we talked about it before, but just even general, the timing of bad faith, and is there meetings that go on behind the scenes where people are worried about bad faith? Is it a denial process and they don't think they've committed bad faith? If you don't mind, let's explore bad faith a little more.
Yeah. So, we all know this, that there are these big red, bright, flashing buttons that we want to push that get something, quote unquote, set up for bad faith, or gives us that opportunity for bad faith. And that's, going over the policy limit and, putting the insured at risk for their personal assets. On the defense side, you would get these letters usually that are saying, hey, it's a policy limit demand and you have, 30 days to pay this, or I'm never going to talk to you again. Most of the time, the defense lawyer, I could very easily say, okay, yeah, but here are the 5 things that are unknown about this case, and you haven't given us any information about that. And before I can make a determination about whether or not this is a policy limit case or not, I have to know this. Okay, we've all seen those letters. I've written so many of those letters because that sort of staves off the bad faith, saying that I legitimately, as a defense lawyer and the insurance company, legitimately don't have substantive information to make the determination. Okay. And so on the timing of things, if you're sending these letters, right away, and there's not sufficient information to determine whether it's a policy case or not, well, my view is you're looking foolish and you're looking weak, and it weakens all of your subsequent demands. Okay. I mean, if it's a case and it's $100,000 policy and you have someone who has, 40% third degree burns over their body, okay. You don't need to do a whole lot more than to give them, maybe the medical records. But if it's something that you're saying, hey, I'm going to prove this up, and my client is so great, now we're, instead of a $1 million policy, I think it's a jury's going to come back with 2 or 3. Well, that's something that you're going to have to give them enough information. And if you're not doing that, well, it just falls flat.
Well, Jason, and I know you have more to say, but it seems to me you're kind of saying there's the boy that cried wolf situation going on. If there's a lot of unknowns and they're sending you a settlement opportunity letter or demand that has basically policy limit demand, I'm not talking to you anymore, and then they come back and talk to you more, they're really not doing themselves any favor. Am I misunderstanding what you're saying here?
No, not at all. I think that's spot on. I mean, there is a reality out there, that the insurance company knows if it's a close call, right? If not everything has been perfectly presented and timed out. If it's a close call, they know that you're saying I want your $1 million or $300,000 policy or whatever it is today. They know that in 4 months from now, you're probably going to take it, or 6 months from now, you're probably going to take it. And they know this because why? That's what usually happens, right? And so, establishing your own credibility and giving any, credence and force to these letters that you write, you have to stand by it. And it's hard because, things change in our cases too as they progress. But, it goes back to only making those policy limit demands and the quote unquote bad faith letters when it's the timing is right and when the case is appropriate. Because if the timing's right and the case is appropriate, well, then you can, very comfortably stand fast and say, no more. I'll talk to the counsel for the insurance company and the personal counsel for the insured, but I'm not going to talk settlement with you, defense lawyer.
Well, Jason, let's go back to that first instance you referenced. Hey, there's a policy limit demand out there. You don't have what you need. The defense attorney writes back, this is what I need. I think we find ourselves in a situation where we comply with that request. And then, 4 weeks later, 6 weeks later, we get, hey, thanks for that, but actually now I need this. And it feels like you're being drug along. And why didn't the defense attorney say those other things from the beginning, right? They could either be known or guessed to be known at that time. It seems like there's a little bit of a game on the other side, and maybe that's just a perception, but it seems to me that these are drug out as long as possible.
They are, and I think that it's in part it might be somewhat of a strategy from the insurance company, but really it kind of gets back to some of the stuff that we've talked about earlier. Is that these adjusters, number one, they're human and they are overworked. And so they are juggling far too many cases, many of which are going to have, similar types of demands. And so in order to pay significant monies out, they have to have their file appropriately documented because their files get audited by outside auditors to make sure that they're complying and not just giving money away. They get reviewed by their supervisors. So there's a lot of stuff that they just sort of need to have in their individual files before they can pay out significant money. Now, when you have a policy limit demand, I've had multiple adjusters tell me over the years, I can pay you, say it's a $500,000 policy. I could pay out $490,000. And that's one thing. But to get that extra 10 that it's a policy, well, then we have to go to mediation. It's just a policy of the company, or we have to do X, Y, Z. And so sometimes it may seem that they're dragging things out, and they are time-wise, but they are trying to do things to meet the requirements of the insurance company.
Well, Jason, would you ever go tell the plaintiff's attorney that? I mean, it's a weird situation, but would you counter with a 490 on a 5, or would this kind of be backroom, unknown talks that are going on, and the plaintiff is none the wiser and they're really knocking on the door and just don't know it?
So I would. I would call you up and say, hey, here's the deal. If you want the policy, it's going to take a lot and it's a pain in the ass. But if you take a little bit of a haircut, we can get it done right now. And I would say that, and it didn't put me in an ethical quandary from my point of view in any way. But it's just being upfront and honest, right? What I am finding as I have transitioned over to helping people on the plaintiff side is not all defense lawyers were trained, like you and I were, from a very good firm with great mentors. There's many more that are out there who are seeing sort of the insurance company as the client, and they're just taking these hardline stances that, it could be the insurance adjuster, just speaking through them, and it's frustrating. And so I would do stuff like that. And if you have a good relationship with the defense lawyer, especially armed with this information, you can ask them, hey, why do you want to go to mediation when you have all this stuff? Why do you need all this extra information when you have what's appropriate? What gives here? And they might tell you, right? If you take it from the standpoint of, God damn it, you guys are just dragging this on because you want a bill, or the insurance company is a terrible company and you're dragging it on, well, you're probably not going to get the real deal from them.
No, and that's great advice. And honestly, those other battles don't get you anywhere, right? Complaining about policies, practices, or using their slogan against them really doesn't advance the ball for our clients.
No, it doesn't. And it's sort of, it's a bad thing to say, but that's kind of lower level advocating, whenever I would see that. That was always my view.
Well, I think one of the problems we're facing too, you talked about an example of, well, let's go with the extreme example. There's a $100,000 policy. We have $100,000 in meds. That's going to, get turned over pretty quickly. How much are the insurance companies looking at non-economic damages when they're considering these giving the policy up?
Yeah, I mean, I think it depends upon the case and the types of non-economic, damages. When you have scarring on a face versus, a scar on somebody's back, a scar on somebody's back that's a male versus a scar on a little girl's face. Those are non-economic type intangibles that will play big into an evaluation. But it plays big into an evaluation because they probably have some database with metrics on how much more a scar is going to drive a verdict or a value, on a little girl versus a male, right?
For sure. So, go ahead, please.
No, I just was going to finish up where when you have the non-economic damages, those are the intangibles that we look at that drive jury verdicts, right? It's part of the story that people can relate to. And, there are so many instances where people are just brilliantly saying, we have legitimate large, $400, $500, $1 million in medical expenses. We're not even going to ask you for those. It's not even going to come up at trial. And, sometimes, as those numbers in front of a jury start to kind of anchor where they can come, where they come up with their values. And it certainly does with insurance adjusters. They always go to the economic loss. What is it? And then they build from there. And in some cases, that's appropriate. In many cases, it's just not appropriate. But it takes a lot of courage to say, I'm not going to go through your metrics and your paradigm for valuing cases of, okay, it's 50,000 in meds. And so, maybe this is a 4 times the meds type of a case, and saying, nah, I'm going to blow it out of the water because the story and the injuries are so compelling.
And I'm glad you brought that up, Jason. I think episode 5, we need to talk about waiving either medicals or certain types of economics. It's just a whole other subject, but it's something we're all talking about. I think it's an important thing to talk about, but maybe not this one. But if we could go back, you talked about scarring, and I'm glad you did, because that's easy. But what's going on behind the scenes when it comes to care, comfort, support, consortium? those other kinds of non-economics, the insurance company, we, should be considering, and certainly we want the jury to consider, but it doesn't seem like they're paying on those too much.
Yeah. And I'll tell you from the defense side, I never was too moved by those unless it is something where, someone is catastrophically injured and it's changed the spouse's life because they're now, it's not a situation where, the husband is in a bad mood all day and I'm not trying to minimize that, right? But a difference of the husband's in a bad mood all day because his back hurts because he has a 3-level fusion or something like that, and we can't go out and do the things we used to do as much. Okay, versus I'm now a nurse, right? My whole life and everything that I had in store for myself of going to visit grandkids and going on vacations with my husband or spouse when we retired, all of that's out the window. Those, I think, are significant for sure, and significant from the standpoint that insurance companies can look at those. But I also think that those turn on the presentation of the spouse and the presentation of the spouse at their deposition.
Yeah, I remember way back on a case a long time ago that you and I had where we deposed each spouse, and although they witnessed the other person's testimony, they testified completely opposite of each other on these losses. And I'm not proud of it, but at the time and working on the defense side, we're like, well, gosh, like that claim really means nothing. Because they don't even have their story straight when they're sitting in the same room.
Oh, for sure. And, one thing too, and it's something, it's not too off topic, but for us to prepare our witnesses and our spouses when they testify is if a defense lawyer is good, what they're doing, what I always try to do is, especially with women, and it usually happened with women, is you would talk about how much they're caring for their husband who's injured. And in a kind of weird way, this injury and that care has kind of brought them closer than they've ever been. And 9 times out of 10, they say, oh yes, we're now closer now than we were prior to the injury. And so it starts to negate all that stuff. And, when you have a spouse who is testifying about loss of consortium in their deposition, get the injured plaintiff, get them out of the room, right? So that they can be a little more candid and tell them, I'm not going to share this transcript with your spouse, so that you can be more candid, so that they can actually get that out there. Because when they're testifying in front of their spouse, they're going to mitigate almost everything that they say, unless you really, really work with them and give them the best opportunity to get that out there. And so that's just kind of maybe a practice pointer where I would see plaintiffs' lawyers really kind of screw that up, because they wouldn't work with the spouses. And then they would set them up for failure where, the husband is looking at the wife as she's testifying, and you want her to say, yes, I lost everything and I can't view him as a husband anymore because he's now just a patient. It's very hard to get for them to do that.
Oh, that's great advice. And that actually does go to even the one I was referencing from way back in the day. So I appreciate that, Jason. I know Courtney's about to cut us off, and I'm excited actually that we didn't get to some of the stuff that we wanted to talk about, and I'm actually even more excited if we can talk in the future about waiving meds or certain economic damages and the strategies that go into that, and how that makes you feel and how scary it can be, and getting the client on board, but taking that risk on the others with the jury. So hopefully we can meet again.
I would never cut you guys off. You're the best. You can have as much time as you want, but I do know that our listeners, we will keep them salivating for part 5, it looks like, which, I mean, if that's not a Christmas, Thanksgiving gift to everyone, I don't know what is. Jason, just to recap quickly from our episodes 1 to 3, if there was, this is going to be hard too, but if there's one piece of advice or something that you think that everyone should go back and really, if they haven't listened to those episodes, really drill down on, can you just sort of give that little bit of information on what you think was a really good takeaway from one of those episodes that we spoke about previously?
Yeah, I think the biggest thing is to be prepared. And that might be that you have to go spend the $20,000 to get the damage experts, lined up before you make your demand, or even before you file a lawsuit, if you have the time under the statute. But being prepared and, showing the defense counsel and insurance company that this isn't going to be a fair fight because I've got it all, right? That's the biggest thing. And it to me, because it drives reserves, it drives just perceptions, and it can then overwhelm them. And I think that's the best advice that I can give.
And Jakob, I want to ask you the same thing, a piece of advice or a great takeaway from part 1 to 3.
Look, share early and share often. Don't play a game where I'm not giving you this until we're in litigation, or I don't have to do this, or I don't have to do that. If you know that you have something that's ever going to come into the case, ever, even if it might be under a court order, give it to the defense, give it to them early, always do it. Make it, part of your practice, and don't play games.
For sure.
Awesome. I love it. I appreciate it, both of you, so much. Jason, what's your information if people want to contact you about these episodes? They want to co-counsel a case with you, refer a case, just chat with you because you're a very lovely gentleman. Give us your info.
Yeah. So 2 things. You can email me. It's Neville@SpenceLawyers.com, or I'm rarely, if ever, in my office anymore. So call my cell, which is 307-262-2413. And, I know Jakob is like me. I love strategizing about cases. It's great. I love it. And so, call me up. I'd love it.
Perfect. Jakob, same for you. Where can people contact you to work with you, or just to pick your brain about something that they're stewing on and they need your help?
Look, this really is what we love. So it's always good to talk about what you love. And so I want to encourage people to reach out and ask questions. It doesn't mean you must co-counsel with them or you must share your case. I think the sharing of ideas is what's most important, since the average size of our firms are 2.5 people across the country, not 20, not 100, not 1,000. So reach out. I'm at Jakob with a K, Jakob at TL4J.com, or my cell phone number is 307-267-9432.
Perfect. Well, I do appreciate your time. Thank you so much. And we will be back with Confessions of a Defense Attorney, Part 5, very soon. Thank you, guys.
Thanks, guys.
Thanks.